today I was contacted by the California State Supreme Court. And when you're a self represented litigant, quite often you're going to have to cure, meaning you may file a document and the higher court is going to say, hey, you need to do X, Y, and Z to get this right. It's a side effect of being unrepresented. It's a hardship, but it's a learning process and it's beneficial um, for other people. If if you learn something and you're able to share it with other self-represented litigants, that can then help them along the journey. They may not have to um, weather an obstacle that you did. You may have successfully negotiated that obstacle, and so that you can share that information, you can disseminate what you learn. Um, a very wise one person once told me that we don't always learn from people who are successful, that sometimes we can also learn from people who fail. And we can either learn to not make the same failure or go down a certain path, or we can learn potentially how to navigate it and be successful by their failure. Like, okay, that person went left, they should have went right, they went up, they should have went down. That's what I mean. I try to do my best to simplify things because putting it in a context that makes it digestible is so important. So I'm going to try to do that right now as I explain. So I had filed a writ of certiorari to the United States Supreme Court, and I missed important filing deadlines because, as I've expressed to you guys, I had a 42 USC 1983 civil RICO action that was active in the Eastern District of Virginia. That 42 USC 1983 civil RICO is it's before the Fourth Circuit Court of Appeals in Richmond, and I'm still battling in Napa, California. I filed mandamuses. I consistently go into the courtroom and I file requests for things like ADA accommodations, for auxiliary aides, to record the hearings. If I have a valid diagnosis that far predates any of my legal court battles, right? My diagnosis is from 2010. So I'm not going into the courtroom and trying to play the game or trying to manipulate the outcome to my favor. I have a legitimate qualified diagnosis. Remember those words, qualified diagnosis. And with these diagnoses, there's certain reasonable accommodations that you can request. Some accommodations are not going to be reasonable for your disability if you seek to assert your rights under the Americans with Disability Act, but some of them are. Let me make sure the Wi-Fi is on so that I'm not streaming on a bad signal here. Okay, yeah, no, it's good to go. And so post-traumatic stress disorder, it does, we're asking to record, asking for auxiliary aids. PTSD actually changes the brain from what they say. It is definitely a communication issue, and access to the court is a right under the law. And so my diagnosis far predates any of the legal endeavors that I've unfortunately taken on. And I didn't wake up. I had a really good life. I get to get up and be people's ambassador to the Napa Valley, and all day long I'm taking people to enjoy wine experiences and fine dining, and I get to be part of their journey. I got to be an ambassador to their life experience coming to the Napa Valley. It was an amazing job, and you get to see the lifestyle. You get to meet all these people, and they're there to have a wonderful time. They're enjoying themselves. So their energy is very positive, as opposed to being, say you work at a bar or a restaurant and people may be having a bad day and they come in there and they may use you to vent their frustration on or take it out on you. That's not how Napa is. These people are there. They're well fed. The wine is good. So the energy is good. So that comes out on how you go home every day, because you get to go home feeling good because you were treated well, and so that was a fringe benefit of being a driver. So I didn't say I wanted to take up this battle because I had something that was missing inside of me, um, that I needed to fill. I didn't, and I've noticed that there's a lot of folks out there. They want to go out into some kind of a battle, some kind of civil rights. They went to school, or and they see people that are part of movements or that have been part of movements, whether it's, the Huelga, Cesar Chavez, Dolores Huerta, Martin Luther King, you got Malcolm X, and Langston Hughes, all these different folks, civil rights movements. And a lot of times people will see them in documentaries, or they're, completing some kind of curriculum, and you're captivated by seeing people and the sacrifices they make and the hardships they do to better a way of life for other people. And that does pull people in. It has to. So many times people are just, they're watching as spectators, and they're like, man, I wish I could have been in that fight, or if it was here now. So I think that it's a call to action sometimes for some people. But what is missed is the hardship. It's easy to watch it through a screen and be like, oh man, I wish I was there. I would have done this if I was there. And they don't realize that those people suffered. There was days where they were hungry. They lost people along the way, and there's, it's people been physically harmed. And so I have already fulfilled that self-actualization, as I call it. I don't like to always quote Maslow. I'm not like I don't subscribe to Maslow, but the self-actualization pyramid, it makes sense that people are going through life and often trying to hit certain benchmarks that make them feel actualized. Oh, am I a homeowner? Do I have a degree? Am I this? Am I that? Have I done this? Because often in society, people will say, if you have not done this, then you have not achieved. And so with somebody like, ooh, their home, they have a car, they have a house, they have this. So other people look at them as being successful. But the self-actualization is like, what does it take for you to be comfortable with yourself? And some people have all those achievements and they're not okay with themselves. And I think that's why you see people gravitating towards doing stuff that's like, man, why are they doing that? Because they're still trying to self-actualize. I had already achieved that. I was content with being a father and a husband, having a family. That was all I cared about. I didn't need to have all these other things to be able to walk into a room and be like, oh man, I've said as much before, having deployed and worn the United States patch on my arm and the big red one to go protect human life, that put me in a different category, because there's a lot of people that can do a list of things that they've done and that won't be on it. And so you can walk into a room where people may have 4 or 5 check marks that you don't have. And that one check mark, they could be like, they want to hang out with you, like, hey, tell me about it. What was it like? What happened? Like, you see a lot of people that go to combat. There's people that want to hang with them. Like, what was that experience like? Because it's something that only those people will understand. And somebody may feel superior to somebody, but when it comes to that, they're like, yo, that's something different. But again, that's another thing that comes at a great cost, that they may think that that's what they would want to have done or experienced so that they would be self-actualized. But those people may be suffering horribly, with PTSD or the memory of loss and everything. So sometimes things, just like street credibility, same thing. Some people think they want street cred and they don't realize the pain that may come with that. It's not, some people just want to go and like shimmy and stick their foot in the pool and be like, oh, I wouldn't spend like a week in the ghetto in the hood, man. So I'm hood too. Like, no, you're not. It's like the people who grow up and live in it and they go hungry or suffer and lose people along the way to addiction or whatever. Those people understand that stuff is real. And I grew up in Napa, Vallejo, and San Diego. And in Napa, a lot of people they'd go spend the weekend somewhere where it's rough around the edges and come back and like, yeah, I spent the week over. I was over in East Oakland for the weekend, and my cousins, and all the other people like, ooh, let me touch your shirt. It was, and I remember growing up and seeing that. But when I lived in Vallejo, it's a whole different thing. It's like people, that's just reality. It's not like, oh, I'm going and spending the weekend over here. No, they're there every day of the week. It's and 365 out of the year. But sometimes people will go from a place of comfort and they'll just go stick their foot in the water and like, oh, it's cold, it's cold. And and then run back to wherever comfort they come from and think that that gives them an understanding of, and there's a lot more to it. So I didn't wake up and decide I wanted to battle Napa County and Allison Haley and these other people. I didn't, and it's a horrible experience. But there is nothing, and I mean nothing on this planet that I will fight harder for than to protect my son. And so I filed a writ of certiorari to the United States Supreme Court. I missed the filing date. They gave me 60 days. They gave me 60 days. I'm trying to cure this stuff and navigating the federal case and the cases in California. Extremely difficult. And there's the cases in DC. So I did realize, though, how to get to the Supreme Court and what to do now. So now I'm much more effective. Also navigating the state Supreme Court and the appellate court. And I think I've been able to go through everything and find the just abhorrent, like flat out malfeasance, where things are like cut and dry, and there is absolutely no way that they should have gone this. But if you don't have an attorney or you don't have people to help you out or the resources, it's like it could be the worst that's been done to you, but it may mean for nothing because you don't know how to battle it back out. And then sometimes, whether you do or you don't, again, they have control of the levers. And that's what I'm trying to show people that may be naysayers or skeptical about some of these people that are stepping out there and saying, hey, no, man, I didn't do this. I didn't do wrong, but my rights are still abridged. Because a lot of times people are stepping back and they're like, how can that be possible? So we have to be better at showing people, like giving them the full meat and potatoes, give them the chronology, the schematic, the flow chart. That way it's like, okay, now I see it. But we have to show them. We have to be better at that. And it's so hard because there's so many variables and people on the outside looking in, they don't experience it. We who are weathering the storm, it's like, oh yeah, they did that to you too. Oh man, or they did that to you. Oh, this is how they do it over here. It's much similar, but this, so those of us who suffer understand. The people on the outside, it's an uphill battle to try to get it and to compress all the facts and to just it's to make it concise. It's so difficult because it's like saying, hey, I want you to take 50 gallons and pour it into this little 2-liter cup right here. How the heck are you going to do that? Right. And I noticed that from the outset, that's one of the huge challenges off the jump. How do I make this digestible for somebody that doesn't have any legal knowledge or experience or understanding of what I'm suffering or the reality that you can even suffer this no matter who you are? We have people that are former law enforcement, firefighters, doctors, every walk of life that most people would think, oh, well, the reason why this person's suffering is because they're not this or they're not that. And we want to show you guys that there are people that are this and they are that. They have money or they have friends or they have this or they have that. They have an understanding of the law and they still walk into a buzzsaw. And so there's not quite a rhyme or reason, but there is in many cases. And quite often it's the people that are controlling the levers. So if I have a duty that if this happens, that I'm supposed to pull this lever to make this not go any further, right? If I'm the person, say I'm the judge, and if this gets to here, I'm supposed to be like, oh shoot, pull this lever to stop that from continuing up. But if I don't pull that lever and it keeps on going, that's why it doesn't work. And that's what's happening, is that there's musts and there's shalls, there's ministerial duties that are being completely pressed aside. And one would think, well, all you got to do is file a complaint about it. But then again, the people controlling that machinery are not pulling that lever. So it's multiple layers of people who have a duty who are failing. whether willfully, intentionally, ulterior motives, it does not matter. There are musts and shalls and levers in place, guardrails that are being made ineffective because the people that are supposed to do a task and have a duty to do so, they swore an oath to do so, they're failing to hit that button or pull that lever when that guardrail needs to go in place. Um, so some of you have seen me do my oral arguments to the first District Court of Appeal, First Division, Court of Appeals, California. I made the arguments to them. I've stepped back and looked at a lot of the cases that go before the Supreme Court. A lot of people will tell you, oh no, it's if it's not this, if it's not that, and the percentage window. So okay, we know what does not work, and we know what makes something less cert worthy or what puts more obstacles in the way. So what are the things that don't? How do you navigate a path? And that's what infantrymen do. Is we're trying to figure out, like, let me see. There's a mountain right there we got to get to. If we go down this valley right here, there's a whole bunch of opposition. So instead of trying to fight through them, we should go around them, right? So that's what people are supposed to do. They just think that, they're just going to want to push through it. Well, what if trying to push through that obstacle, it destroys the mission, because the people that you needed for the mission are no longer there because you lost them trying to press through. So it's looking for the least path of resistance, which in this case, there are very few. Every path is going to be resistant. But trying to find the most conducive path is the best you can do. So presenting my argument as one of national security, and I'm not trying to be funny, I'm not trying to be hyperbolic and I'm not trying to pump it up, but because a lot of this took place on an international border, specifically in San Diego, that makes it national security. And because a lot of the variables in my circumstance have to do with compromising that border, and the people who seek to do so, and the people that seek to stop that's national security. Not trying to sound cliche or trying to make something more than what it is. Now, if people are fighting criminality or some kind of harm, and they're miles away from the border, it still could be national security if it's the people that are seeking to compromise the border and they have a network, and that network starts at the border, but it works its way up here, then that too can be national security. But if there's something that just operates independently without that, and it's doing harm just in like a town or a city, and it has nothing to do with the border or transnational groups or international crime, then it's not quite national security. But because this is tethered to the border and the counter border operations, et cetera, it falls in under that blanket. And then again, in 2025, when the new office administration came in, they augmented the list of what's known as FTOs, right? They put certain groups on there. And so if your issue has anything to do with those groups or that endeavor, then it makes it even more so a national security issue. Now, one of my main arguments is, look, let's say, okay, one of the counterparts or the main opposition would unfortunately be my spouse, right? And the people that are responsible for taking human life and doing a lot of harm, and people that would seek to dispatch myself or others who stand in opposition to them, we'll call them this, right? And then there's me. So these people, let's say here's my first wife's father, right? And so my spouse doesn't know him, but he was dispatched by these people. And she has a relationship with these people by that includes a past of criminal conduct, but that past segues into the future where that connection and that bond still exists. So I have a connection to her. I had a connection to my first wife's father. And so when I make my argument that if this person made a threat, say, if this person said, hey, if you bring up my criminal history connected to these people, then I'll make sure that these people know what you did in response to what they did to this person, right? So imagine if you're a litigant and you have to go into a courtroom, into a setting where you have to walk in there and the opposing party has that power and that strength that they've made a threat that if you bring up my connection to them, I will use that connection to make sure that they know what you did about them taking this human life and other human lives, right? So that makes the threat credible. And if you were having to go into a courtroom, and if you're accused of something by that opposing party, and you need to respond or to defend yourself or to present a legal argument, but to do so opens up Pandora's box, right? Let's call this Pandora's box right here. We're going to call this Pandora's box. Oops. So how then can you have equitable justice? I'm just going to make it like we'll use the Gambino family, right? Say you were married to a woman, and I'm just using the Gambino family as an example because like that's a name that everybody knows, you know? But say some dude was married to a lady who was the sister of one of the Gambinos, or a friend or somebody that was actively engaged in criminal conduct with them, and they go into a family court setting, and let's say the Gambinos had smirked or plucked that person's family members and they felt some kind of way. What if they retaliated in one way or the other? You know, what if they retaliated or sought recourse because they didn't want to just sit there and do nothing? And then it has to go into a courtroom where that person who is connected to them is the respondent. And that person says, if you do this, then I will do that. How then can that person properly litigate? So this is a focal point of my legal argument. It has been from the outset because they refuse to go in camera and to provide an arena where there's an even playing field, where it would matter for nothing under certain circumstances what she had to say. But if those people, again, that control the levers, that here's a lever, right? And one of the levers in this circumstance is supposed to be, they're supposed to control the courtroom, and there's must and shalls in place. And if certain things happen, they're supposed to do this. But if they don't do this, then that measure that's supposed to stop this from going up, it's useless. So refusing to go in camera like Honorable Victoria Wood did, well, that created that failure in that lever, right? Because then what it did was it opened up the door for the opposing party and that litigant and the attorney to abuse the fact that that lever wasn't activated. You know what I mean? Whereas normally that lever means you'd go into the judge's quarters, which judges go in quarters for many reasons. They bring children into the quarters and they speak to the children and blah, blah, blah. And there's a myriad of reasons. And unfortunately, I would later learn by one of the parents who have been on the business end of this. I told you guys about a child, well, not a child, but a teenager who sought to be determined as an emancipated minor. So he is now an adult in the eyes of the law, but he was a child in the county of Napa, and both of his parents had resources and money. The father had won a major lawsuit out here in the Commonwealth of Virginia. The mothers came from a family of means in the county of Napa. So them getting into a legal conflict gave the court the ability to pluck a lot of that money. And unfortunately, that's what happens. And since both of them had resources, the court was incentivized to keep this going, right? And during those proceedings, Honorable Victoria Wood went in camera for them. They're wealthy. But I asked multiple times, and I explained it to her, that if you do not go in camera, it can lead to loss of life. You know what I mean? That this is exactly what this person said that they would do, is they would seek to extract information and that they would relay that information. And doing so is effective only with certain information. She needed a roadmap. And because Victoria Wood consistently failed and refused to go in camera, that gave them the opportunity, because then they can ask questions, they can demand it, blah, blah, blah. And if you're in a circumstance where you have to pick your safety and your life or to protect your child, I've said as much before, that if somebody says right now, hey, you have to pass in order to save your kid, that's a decision that the bulk of us would make instantaneously. Take my life right now, bam, go. You know what I mean? Like, hey, you got 3 seconds to make a decision whether you get to live or your child lives. People are going to make that decision to save their child, right? That's one of the few. So to be placed in a legal conundrum where to protect your child means you have to allow them to subject you to this, but the judge could have stopped them, and she stopped them far too late. And she did not pull the lever. So when I found out later that in that other circumstance and many others, she did go in camera, I was disappointed, because her conduct and her refusal to pull that lever and telling me that, oh yeah, no, the Constitution and yada yada. Like, so it was okay for them who have a lot of money to go in camera because they need to keep stuff off the record, right? Because that's why you go in camera, is something is so volatile that it needs to be off the record. So that's when they set aside the Constitution under those circumstances. But in my circumstance, it's the law. It's the law. It's not supposed to be like, well, I don't know. And that's exactly, unfortunately, what Honorable Victoria Wood did. And at the end of the proceeding, and I told her, these two cannot be trusted, man. These two cannot be trusted. And unfortunately, at the end of the proceeding, it was too late. You know what I mean? And by that point. And so once that happened, the cat was out of the bag. The toothpaste was out of the tube, and you can't put it back in there. You could probably put a cat back in the bag, but not in this circumstance, right? So number one, you have the failure of refusal to go in camera when they were supposed to. Then you had the other party exploiting that. But I went to great lengths even before that to prevent this. I went to the Napa DA. I sat down with Alejandra, whatever her name was, the DA's victims' rights advocate. I gave her the information that she said she needed, and they pulled away and refused to, because they started to look into it and realize, okay, this is not gonna look good for us. So they could have done something. And I went to Neil Bowman, and Neil Bowman actually got angry at me for asking for him for help to protect my kid. And he said, why is your circumstance so complicated? We only deal with basic stuff, and I told him straight out, I was like, you know what? Thanks a lot, man. I'm coming in here asking you for help to protect my kid, and you're perturbed about it. Man, he was such an abrasive individual. And he got worse over time. There'll be times where he seems pleasant, but it's a facade. And they're looking at putting that dude on the bench. They have him as a pro tem judge. Oh man, bizarre. So I went to great lengths to try to make it so that they could not do the thing. But when it got down to the nitty gritty, it's like, are you going to put yourself in harm's way? And not voluntarily, not willingly. It was an exploitation of the machinery of justice by an attorney named Gregory Carl Winter and his client, the Napa County social worker that was arrested with these people and lost their parental rights for the sophisticated criminal conduct that this person was engaged with them. And so the people that are in control of the levers and those mechanisms, well, that person has been who they've based their judgments on and their investigative findings of this person and testimony they have used to either set aside people's rights or to impose consequence, whatever. So they're in this conundrum like, dang, okay, this person clearly has a history that we did not know about, but we've already had this person do X, Y, and Z, and now we are in a position. So rather than do what was necessary to protect my kid, they chose to circle the wagons. And so at the end of the hearing, despite all the stuff that happened, Honorable Wood put a protection measure in place, but later she would make a ruling denying needs-based attorney's fees. Actually, she did that even before that and denied me representation in the proceedings, which would later undo that very protection measure that she put in place. And that I was, so all the sacrifice that I made to try to go make sure that if she didn't pull that lever, which she was not doing, and Neil Bowman didn't do anything to help, and me as I'm not an attorney, I was expected to put everything under seal. And my argument is their recommendation, or they're saying, oh, just go put it under seal, was garbage. It had no impact, because if I put something under seal legally, right, I still have to give it to this person. So if I put it under seal, I still have to furnish that person whatever that is. And then it goes over here, right? When you go in camera, it's over here. The only people who can only place that information or that evidence or anything goes is into the judge's quarters right here. And you and the other party go in there, it doesn't leave there. But if you have to put something under seal, you file it with the court, you redact it or whatever, you still have to furnish it to these people, right? To that attorney, Gregory Carl Winter. So the fact that an attorney would willfully, intentionally try to manipulate the mechanisms to gain access to operational information that could be given to his attorney, his client, who made the threat to hand it over here, you see how that would create a lack of due process, because you're in a position where you have to make a life and death decision to just go in there and represent yourself, where if I was represented by an attorney, they would have been able to make sure that didn't happen, because they know the laws, they know the rules. But I cited the laws, I cited the rules, I did my research. But again, I can cite it all day long. If the judge doesn't pull the lever that they're supposed to, and then it fails. And so in that circumstance, because of Victoria Wood's refusal to allow to go in camera, that allowed these people to manipulate that. So I say to the Supreme Court of the United States and to the Supreme Court of the state of California that I never got a fair chance at a trial, because I was always expected to go in there with a qualified disability without accommodations, because they kept denying them. They didn't want no record of what they were doing in that courtroom, because when they don't want a record, that's because they know they're about to do something they're not supposed to do. And they're furious at me because I can prove without a doubt they've done multiple, like it's egregious. The more I've learned, the more I'll be reading through something and I'm just like, oh my goodness, damn, they didn't just do you dirty, they did you dirty, right? And I just learned in the last couple of days doing the research that what many of the people that are defendants in the 42 USC 1983 Civil RICO, it's a crime, like straight up. No exceptions apply to the statutory language of what they did. So there's the civil things that they did, and there's the criminal aspects of their overt sequence of overt predicated acts, right? So I'm preparing the next step. There's an action that I've recently preferred in the nation's capital, and I have to add all this into it. But I also have another action that is on the burner, and this is all going to be part of that. But as you navigate the storm, as you weather this tempest, the more you learn, and then you thumb through the documentation, the more you realize, and they bank on that you don't know that. So that would be if you have an attorney's going to be like, Your Honor, per code 34, blah, 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 case in point, yada, 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 controlling precedent, Your Honor. And so the judges are less likely going to play that game because an attorney is going to make sure there's a record, and so that if they do you dirty, you can appeal it properly. Because if you don't know anything about younger abstentia and judicial immunity, well, according to the rules and laws of judicial immunity, they say that an appeal is the proper way to deal with an erroneous ruling. But if you're denied a record, how can the higher court then make the assertion that your rights were violated and give you redress? So it's a farce unless you have all that. And so when they're placing obstacles in the way of you achieving having a record, so that when they're ruling improper and erroneous and they seek to assert their judicial immunity, that you have a pathway to undo that harm if it is improper or erroneous. But when they remove something like the record, that court of appeal or that Supreme Court, that higher court, has no way. They have to give deference to the lower court, assuming they got it right if there's no record. So when they're putting these obstacles in your way for you to get a record, that's willful and intentional acts. So this argument in the mandamuses, in the habeas, I've made this consistently, and I've learned that in each one of these habeas, mandamus, certiorari, yada, 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 I have to file the 2 writs of certiorari to the United States Supreme Court. I'm actually going to go, I won't say when I'm going to go, but it'll be soon. I got a phone call yesterday towards the end of the day, and I try to stay close by where I do this at. Obviously you can see I use libraries, so that if I'm given a directive by the Court of Appeals or by the Supreme Court of the state of California, that I can fix it right then and there and shoot it off, because time is of the essence. And we lack acumen, so a lot of times we need that time so that if we make a mistake, that we can cure it or correct it. So I wait. So I got directives yesterday. I fixed it. I worked until the library closed, and I didn't get it done, but I fixed it. So I've put together a writ of habeas corpus that is just like, it hits all the bells and whistles. And it speaks of this right here. It speaks of the abuse of the PC 1368, which some of you have heard. That is a clear, I hope you guys heard that. That is a 100% abuse of the machinery of justice by the arbiter, Mark Bosnecker, by the attorney, Kendall Barrett, and by opposing counsel, Lauren Noga. And I'm going to actually show you again. We have a duty to show people. If we want people to stand by and be like, okay, I get it, we have to explain it to them so that they understand, because they are not litigators. And any expectation for them to just understand all this stuff that we're saying is not realistic. So may I show you guys? All right. So what we have right here is the complaint filed by Allison Haley, the district attorney, and Rima Brial, This was preferred against me when I was in Washington, D.C. If you don't know why I was in Washington, D.C., I traversed the nation to go there. Some of you guys know who Dallas Wallanaga is, who's in custody in Nebraska right now for a felon in possession of a firearm. Ooh, that's a rough one. Some of you guys know him as Malibu Dallas, but him and somebody else, they were saying that, hey, we have these senators and they're willing to do an investigation into the flow of the money and blah, blah, blah. We need you to write into this thing right here. And I was one of the people that did it. And they said, if you like, you can go to DC. I had also initiated a congressional inquiry, a request for a situation report to the Department of Justice, to the FBI, as a situation report in response to my complaint to the FBI for exactly all of this, right? So unlike this person, when, if somebody threatens you and you don't do something about it, like go make the proper complaint, it doesn't make sense later on, right? But Congressman Mike Thompson was reaching out to the DOJ allegedly to request a situation report relative to that complaint to all of this. And so I went there for all of that stuff. One of my brothers was found deceased in Georgia. He was fishing and he was found, had some kind of a medical emergency, some say. So I went to Georgia first and I brought you guys with me. You can see the videos. And then I continued north into North Carolina, where I linked up with the woman that I got on a plane and left California to stand guard over her in November, early December of 2023. And I would return to California. And that's when I was contacted by the FBI, by FBI agent Cyril Ruffin, in response to my complaint. And again, at that time, I did not know the county of Napa was under investigation or certain people and parties. I didn't know that. It wasn't public information till days later. But I did what I was told to do. I had to explain that I had already went to the district attorney's office, and that I did not have confidence in their willingness to do anything. And so I was given an email address to furnish email to, and those correspondences between myself and the Napa district attorney, that I was to relay them to that email address. But he did agree that I should act as if that I should understand that the potential likelihood of these people being in possession of the information that this person was able to abuse the machinery of justice with their attorney and allocate is now in the possession of these people, right? Now, remember, myself and this person created a human life together. So for this person to make the threats to relay that and put human life in danger just tells you a little bit about that person. It also tells you about the district attorney and the congressman and the other people that would begin to work together to conceal their acts. Christine Briseno, all these people. Christine Briseno would put in documentation that she would make public the things that she was informed about and told about as to the imminent danger and the reality of that. So, and then she would make that public. So if you go make a complaint about the safety of your child and somebody goes and makes that public, that's the crime. That is that crime that has, the statute is absolute, no exceptions here. Under California Penal Code 11167 subsection Delta 1. She had no legal right to do so, right? So if you go and you make a complaint, they haven't, so did a direct report for Jennifer Yasumoto. And like I said, I'm learning all this stuff. I've complained about it, which we have to understand what is the legality and the statutory language of the law to be able to facilitate that legal argument, to be like, actually, it says right here, the identity of all persons who report under this article shall be confidential and disclosed only among agencies receiving or investigated mandated reports. The exhaustive list of people who may ever receive a reporter's identity is agencies receiving or investigating the report, a prosecutor in a criminal case arising from the same abuse, appointed counsel in a 300 WIC proceeding, a licensing agency investigating out-of-home care abuse, the reporter themselves with the waiver, a court by court ordered only. A work violence restraining order petition CCP 527.8 does not appear anywhere on that list. It says Briseño had zero legal authority to place your identity as a reporter or the contents of your reports into that filing. There is no exception, no good faith defense, and no privilege that covers it. So Christine Briseño committed a crime by going and filing a complaint and requesting a restraining order and putting things in there relative to me, a complainer, in that docket. It's like if you go to CPS and then the CPS worker don't like you, files a restraining order request against you and puts what you reported into that restraining order. That's a crime. And that's what Christine Briseño did, as did the rest of them. But you have to understand that. And there is absolutely there's no shimmy room. There's no shimmy Cocoa Pop on them. No, there's no shimmy on them. There's no shimmy. She can't say will or will or will or will. Nope, no shimmy room. That's what the law says. The statutory language says 100% she committed a crime. And the fact that they were emailing each other, like that guy, the other guy, Alex Kudos, he, as I'm directed by the ombudsman of the state of California to go to Jennifer Yasumoto, I go to Jennifer Yasumoto, he says, no, you can talk to me. And I was telling them, like, yo, I'm here to talk to the director. I was instructed to speak to her. And so I never said the name. He says, oh, well, I assumed this was the person, even though he didn't say the name. So Dingledork says it right there that I didn't say the name. So how then can they say it was X, Y, or Z? But the fact that he got on the computer and reached out to Alexis Vossmeyer and they disseminated it when I was reporting this stuff to him makes a violation under the law. So he violated the law. He had no legal right to relay that information as me reporting something as significant as this. And he says, oh, he said very unfavorable things. I said the truth. But he didn't want to accept that the truth was the truth. So he felt that they were unsavory or whatever. But this person 100% abandoned their child and was arrested for doing what she was doing for these people. That's the truth. It doesn't matter if he doesn't like it or if Allison Haley doesn't like it or it makes them look bad or whatever. It's the truth. It's not defamatory. It's not libel. And I, as a parent and my child being taken into danger, had a 100% legal right to ask for protection for my son. Imminent danger was clear and present, and all of these people violated the law as a means to try to circle the wagon and hide their conduct and their behavior. Shame on you people. But you got to make that argument, right? So he relayed that information. That makes it illegal. Christine Briseño doing what she did. Becky Craig and the rest of them. So I know you guys like to watch, so you know what it is. Their attorneys like to watch, they like to stop. You guys broke the law. And you guys wanted to hide that you broke the law. And them emails, they're going into the federal record, into the legal action that's preferred against you guys. I had a legal right to go do what I was doing. If these people weren't here and this wasn't here, I get it, man. It wouldn't make no sense. But my argument, yet again, presented to the Supreme Court of the state of California is just because this person works for CWS does not mean that they can't legally say that I can't go and ask for my son to be protected because somebody works for CWS, who is the person that is creating the harm. especially if the person has already determined to be a danger to another child. That exacerbates it. That's the worst part of this, is if this person hadn't already been determined to be a danger to another child, it would be a harder, I get it, it'd be a harder pill to swallow. But all of them, Sonoma County, Napa County, all of them, they all knew the dang, because they have access to that information, right? They have access to it. So my complaints were valid and they were tangible, and they all did nothing to protect their own liability. And so what they're saying is, oh, you can't go make a report. No, you can't relay to other people or put that in your little request for workplace restraining order. I don't work for the county. I was going into a public building. Title II, public access to a building. We got a 1983 and a 1985 violation. And the emails show that they were working together, emailing, hitting people up, trying to create a narrative that did not exist. And law enforcement told them that this is not actionable on our side. Just like Stephanie Johnson, county council told them that, hey, this is not a threat. This is just a disgruntled taxpayer that's angry about something, but this ain't a threat. And they told her she has to give back those emails. Like, no, that's exculpatory evidence. And so what they want to do is park it under attorney-client privilege after it's already been released, because they realize that shows lack of mens rea. It undoes their legal argument that that they were being threatened. They knew they weren't. And what they do is they're behind the scenes, they are pulling levers. They're pulling levers that are supposed to be pulled for something else, to silence people and conceal liability so that they don't have to make people whole, because it would have to come out of the general fund. If a Napa County employee does harm to somebody, that has to come out of the general fund, because the insurance policy that Napa County pulls money from the taxpayer does not cover harm by fraud, or if they do something illegal to you, like, I don't know, commit a crime, that's not covered by the insurance policy, and they won't pay it out. Napa County has to pay that out. Just like they did in the KC Slusher case, that $5 million, I think it was, whatever. So the fact that they're emailing each other and saying, hey, we got to get this done over here. And then you got law enforcement on the email saying, hey, this ain't a threat, man. We can't do anything. And then what do? But Susan Altman, Chief County Counsel, Cheryl Bratton, and the others, Becky Craig, they're like, oh, well, we're going to put together this thing. Because when you file for something like what Christine Persenio did, the burden of proof is next to nothing, especially when Robert Stamps is the judge signing off on it. Who's Robert Stamps? Robert Stamps is the judge who unhooked my spouse, her bigamous marriage. So she was married to me and another man for the duration of our marriage. The man that she was arrested with doing the things for these people, right? And Robert Stamps unhooks them when the time limits had passed. It's 4 years once you know the bigamy is present. If you let 4 years transpire, once you know about the bigamy, you've now accepted that, and you have to go through a traditional dissolution of marriage. They were married in 2010. It was 2023, right? Long past 4 years. But Robert Stamps, looking out for his own self and his own people and the county worker and the county and all this stuff, right? He unhooks them from that marriage. And who's the one who signed off on the Christine Persenio thing? But Robert Stamps. Let me read the complaint to you guys so that I can show you guys. This is the complaint filed by Allison Haley. Hey, one of the things that they asked for here is they want a lot of money going to the nonprofits. They want $500, $200 to some shelter. They want access to your electronic devices. And we've noticed that a lot of these people, that they've demanded access to people's electronic devices. But Imagine. All right, we got Pablo Lopez, right? We got Officer Pablo Lopez. And we have Officer King, K. King. On 3/4/2024, that's when I spoke to Officer King. This one's from 2/29/23, and you can see I didn't even speak to the dude. So if you go to the Napa County Court website right now and you type in my last name, my first name, and you go look up this case, you will see that Officer King is not listed active in the case. So why would Allison Haley not have the only officer that I spoke to active in the case? Only the officer that I did not speak to. Why? Because that officer clearly states right here what would be the biggest challenge for them, and that would be mens rea. I told them as much. So what does Allison Haley do but remove that officer from the case? Isn't that dirty? But these are the things that you have to show people. And when things weren't going their way, right? Allison Haley anticipated that I would just walk into the trap that she had set. Now, keep in mind, I just gave you guys a date of what? 3/4/2024. And I think 2/29. So 2/29/23, which is, I didn't even catch that. That's the year before. So that's the wrong year even. Huh. Oh, I didn't notice that. So just now. And then 3/4/2024. So it was actually, so you know when this was filed? Date 9/12/2024. But there's so many errors on here, man. Gosh. And these people are paid hundreds of thousands. Allison Haley's paid like $430,000. They filed this August. Isn't that interesting? 6 months later, 5 months, 6 months later, when I'm on the other side of the country. So if there's concerns about anybody's safety, why would they do nothing for 5, 6 months and wait till I'm thousands of miles away? You don't have to be a rocket scientist to figure that out. Is they knew that I was in DC and I was delving into my complaints to the Department of Justice against them. So Allison Haley was like, we got to shut this dude up because we have an employee that's directly connected to these people. And they had already taken my son and given no statement of decision. So that was the first stunt they pulled, because 3 days before that, we had entered mediation. We have an agreement that's signed by the judge. 3 days later, we enter into a courtroom and that judge flips it and takes everything from me. And he gives absolutely no explanation, folks. When I tell you that no explanation is given, there is absolutely nothing. There's not even one sentence that says, hey, I took this guy's kid because he went to CPS and filed a complaint, and you can't file a complaint to CPS if you're married to a CPS worker. You know why? Because that's a bunch of horse caca right there. Yes, you can. If I was married to an FBI agent or police officer and they were breaking the law, or I had concerns about my child's safety, they cannot tell me that I can't go there. But that was one of the things that Joseph said that day. Why didn't Joseph Soga put that in writing? Because they know it's foul. But the fact that Joseph Soga put absolutely nothing in writing, and they did so with the DVRO, it violates the law. It's like, it's all bad. So right now, that's before the California Supreme Court. And it's an extremely strong argument, because the Court of Appeals, when I appealed, they said that I didn't challenge the merits of the lower court's argument. What argument did the lower court make? But absolutely nothing. So it was ridiculous, and another indicator that the Court of Appeals knew what they were doing, They knew that there was no argument because they saw that there was none. They never once said, if you hear that, oh, the judge says that you did X, Y, and Z. The only thing that they said was that this person said this and that. That's it. Everything in the tentative opinion and the unpublished ruling that Robert Stamps keeps citing, even though it's a violation of Rule 8.111, you can't use unpublished opinions. You're not allowed to. It's a violation of the law. But Robert Stamps, in his written, verified responses to my allegation, to my request for the 170.1 or 160, I think it's the 170.1, the verified responses, he cited yet again an unpublished opinion. And I responded and I said, hey, man, you can't do that. And on the 21st, when they refused to let the witnesses, and I said, hey, I'm not doing this. Not without the auxiliary aids, the CHS, all the protections, what the law states, and they still pressed forward. And he denied witnesses from North Carolina, from Virginia, Ohio, Texas, California. Everybody was ready to rock and testify. And Robert Stamps knew that if they testified, he would have to take into consideration what they say, and he couldn't just say, oh, well, she says. That's how the law is. And I knew he was going to do this because the hearings leading up to that, he was like, what? Why do you need witnesses, sir? I just want to hear from you. Like, don't try to play me, bro. I can read. If there's no other witnesses, that gives him the ability to just be, it's you and you. And they could be like, I like you, I don't like you. And that's the way it's going to go. And so he was like, yeah, I don't know why we would need witnesses. What? So I knew what he was up to. And he said, yes, you must submit a witness list and any evidence that you need by the 14th. And so on the 21st, they said that I didn't meet that threshold. I e-filed. I have the stamp that shows that not only I filed it, but they received it. And he says, no, you can't because you didn't meet that threshold. All of that's in the minute order where, again, he cited an unpublished opinion, denied the witnesses, yada, yada. That's all I'm saying is the more you study, the more you learn, you know when they're going to do and what they're going to do. It really sucks because you're sitting there and they're trying to play you and they just think like, dang, you're looking at them like, dang, you realize I can read English, man. I read the statutory language of the law. And then they're surprised. It's like they're, oh my goodness, they actually read. And then so when they try to pull the flim-flam and you're like, negative, Your Honor, according to 3044 here, blah, 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 family code, the rebuttable presumption, yada, yada, yada. And then they still play the game. They don't expect that you're going to do the research and be able to catch them when they're doing the dirty deed. But on the 21st, he denied witnesses and they put all this in writing. So that's the significance of that. Why? Robert Stamps is the one that unhooked her from the dude connected to these people. Marvin Lee Mays Jr., her other husband that she had, right? And it don't look good that he was a commissioner at the time, but that a commissioner used his judicial powers to do a favor for people from organized crime, man. You know what I mean? And in his verified written responses, he was like, oh no, I don't know what he's talking about. I didn't participate. He was the commissioner in that circumstance from May the 5th, 2023, where he unhooked. So remember, I filed for divorce in March of 2022. May the 5th, 2023, he unhooks her from her other husband, but she files for an annulment. We show up on January 25th, 2023, in front of then Commissioner Robert Stamps, and I tell him, like, I'm going to probably have to change my filing to an annulment because the respondent is married to another man. 12 days later, she files for an annulment, and I told that judge that in the courtroom. And you're going to say that he didn't realize, like, wait a second, you're already divorcing somebody, so how are you over here getting an annulment from this guy? So when I was able to get Victoria Wood to grant me to amend to annulment from dissolution of marriage, then they told me all of a sudden I had like 3 days to respond. So I went and filed a joinder, paid a bunch of money, and I was adjoined to the action. And Robert Stamps allowed me to adjoin and be part of the hearing. And it's crazy because they said that they denied it, which is false. But that hearing was captured. And so he's furious because that was all captured. And the witnesses that were going to show up on the 21st were going to spill the beans on what transpired on that day because he lied. Robert Stamps is incessantly lying. He said that he said there was nobody in the courtroom on February 20th. January 25th, when it says it in the minute order that he had the deputy clear the courtroom. Then on February 20th, 2024, he lies and says that there was nobody in the courtroom. Oh, that was a big mistake. And where did he lie? But it's in the written report from Honorable Presiding Judge Cynthia Pillsbury Smith, because she questioned him about it and he lied. So I have that in writing. We have what actually transpired that day. Then we have also the witnesses. And I later would see, I'm going to print it and show it to you guys. Victoria Wood was party to that too, because in 2024, they had a hearing with Neil Bowman Davis, Robert Stamps, and Victoria Wood. I don't know what happened. I wasn't there at that hearing, ironically. But very bizarre. So Robert Stamps has a motive to make sure. And when I filed the request to disqualify him, he made sure he stayed in that saddle. And this garbage right here, he's the one who signed the original TRO. So he knows that there was no CPO. Let me show you guys. This guy says right here that a CPO was in place. It says it right there, 24FL000144. So this officer says that for violation of the terms of the served DV criminal protective order. There was no DV criminal protective order. And you know who signed the original, the TRO? And the one who stamped it was Robert Fleshman, the court CEO, and Robert Stamps. And then Robert Stamp tries to jump into the saddle into the other proceedings, knowing that there was no CPO. So like I said, they're all dirty as can be, but you've got to be able to prove it. Mark Bosnecker pulled a stunt on behalf of Kendall Barron and Lauren Noga. A judge cannot just let attorneys, they're not supposed to, but that's what's happening in Napa. The judge, like Mark Bosnecker and Cynthia Ortiz, they're letting these attorneys declare doubts without properly substantial evidence. You could be going in there and be like, man, forget this. I don't want to blah, 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 blah. That is not enough under the California law to assert a doubt. And if I am an attorney, I must get some evidence. Let me see. Well, we got some diagnoses here. We got some hoopla. We got this and that. And I need to clerk. I'd like to file this into the record, blah. And then when I go into the courtroom, Your Honor, pursuant to PC 1368, I want to declare a doubt. I have filed significant evidence into the record. And I want to speak that evidence into the record. And then Mark Bosnecker was supposed to say, hey, I have this evidence. I blah, 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 blah. That didn't happen. So that's the failure. That's the willful, intentional act of Mark Bosnecker, the now retired judge. And that's the exchange between the attorneys and the judge, because the judge is the one who's supposed to pull the lever. If an attorney tries to play the game, it's not supposed to work, because the judge is supposed to say, yay, you are a professional. You are an officer of this court. You are an attorney, ethically bound. You know I can't do this without you doing this. But that's not what Mark Bosnecker does. He's like, yeah, sure. May I approach Your Honor for a sidebar? That means the attorney wants to have a sidebar off the record, just like in camera, remember? So Sang Nguyen has a sidebar to justify a declaration of doubt, meaning there's no record, and then the defendant litigant has no way to show to the Court of Appeals that their rights were violated. This is all willful, intentional act. This is not accidental. And again, Mark Bosnecker is 100% complicit, because he had a duty to say, no, you're not doing this right. I cannot do this. So does Cynthia, Judge Ortiz, Elliot Ortiz. But instead, they're like, yeah, you want to have a sidebar? Come on over, Sang Nguyen. Sang, sang, sang. Sang's a fool. That's what happens when you got an attorney. Hold on. Hold on. Sang. Sang's a fool, right? So the attorney knows what the rules are, but he deviated from that. But again, the judge was supposed to stop saying no in. But no, Mark Bolsnecker says, come on up here, buddy. Come on, sit on my lap. Huh? Get up on daddy's lap right there. He didn't really say that. I'm just embellishing a little bit, right? Might as well have, though. And so saying no in declares a doubt, and Mark Bolsnecker, that's how you can prove his duty was failed and it was willful intentional. Because you can't tell me somebody that's been on the bench for all that time, right? A former prosecutor, been on the bench. Oh, Mark Bolsnecker, 40 years of yada yada. You trying to tell me he don't know what the rules are for PC? He knows. And yet he failed to pull that lever on purpose. Let Sang the Win go to a sidebar. But with Kendall Barron, listen, Kendall Barron's like, I can approach a sidebar, Your Honor. She goes, I've been speaking to, and then she caught herself like, oh, I can't say this on the record. I can approach the sidebar if you want, Your Honor. Listen to the audio. Don't take my word for it. Go listen to the audio. And he's all, no, that's okay. And so then Mark Bolsnecker declares a doubt. So they're working together. There's no like, oh, it's only one. Oh, no, Mark Bolsnecker didn't do anything wrong. It was all Kendall Barron. It was all Sang. Sang's a fool. No, Sang and Mark Bolsnecker were working in conjunction with one another to violate the rights, just like Kendall Barron was working in tandem. And you know, the old prosecutor over there doing the same darn thing. Now, what did Lauren Noga do? Ooh, we have the public records request of the audio. Now, if the officer in this was the only one who identified this improperly as a CPO, that'd be one thing. It still means something. But Kendall Barron, Lauren Noga, at multiple hearings continued to call this a CPO. And she knew that it wasn't. And she was demanding a CPO to create one where one did not exist, utilizing something that was a TRO. So you're not supposed to do that, man. So there you go with Kendall Barron's old scandalous self, right? Somewhere in between stuffing her face with food, she must have been like, oh man, you know what? I got an idea. We'll just say it was a CPO instead of a TRO. Yeah. And then it's in the report, and then I'll go into the courtroom. But yet again, Mark Bolsnecker asks her on the first day, he's like, hey, where's the criminal history? I don't see it. Oh, you can hear the papers rattling around the table. Oh, I don't know. There was police contact. Mark Bolsnecker right then should have said, wait a second. If there's no criminal history to this, how is this a CPO? Because that's the jurisdiction. Family court, criminal court, right? So he knew he was violating jurisdiction. And he knew what they were trying to do, because Mark Bolsnecker knows what it is, just like he knows what the PC 1368 is and what his duties are as a judge to do. He's supposed to stop saying no win. He's supposed to stop Kendall Barron, but he played his part. Listen, he tells Kendall Barron, you don't even got to come up here for no sidebar. I got you. I got you. Who cares about the Constitution? All these rules and these laws and this statutory language and this robe that I'm wearing. What is this thing? What is this gavel right here? Right? It's all a facade when the machinery breaks down. And it is an attack on the machinery of justice when they fail that duty. When you or I fail, it is not an attack on the machinery of justice. But when Gregory Carl Winter is allowed to go in and Victoria Wood lets him demand operational information in a proceeding when I said we need to go on camera and the law dictates as much, that's when the machinery is allowed to be abused. But it's their fault. She could have said, no, we're going on camera. She could have said, no, you are not going to ask that question, counselor. She could have admonished him. She had a duty to do so. She did no such thing. There was times where she was like, stop it, Mr. Winter. But she didn't stop that. She could have prevented all that, man. And the consequence is potential life and death. Mark Bolsnecker knew the same thing. He completely push that aside. Gregory Winter and this person could not have done this if Victoria would have properly. It's like an operator in a dang machine. That machine ain't doing nothing unless the operator's on the toggles right there. You know, an excavator, you ever been in, and you guys in construction, and it's like, you know, or a tank or a dang Bradley fighting vehicle, and you know what I mean? It's like the people inside that turret and that 25 mic on the way, pop, 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 pop. It don't work unless the gunner and you know what I mean? They're up there working together. You got the BC up in the turret, right? Or the operator inside of a damn excavator. He's hitting that toggle left and right. He's going back and forth, right? But if there's no operator, if there's no gunner, that thing ain't doing nothing. So the failure of Honorable Victoria Wood and Mark Bosnecker, it allowed for the manipulation of the machinery of justice. And now I have to make these arguments. And oh man, have I dialed in some extremely strong arguments to not only the state Supreme Court, but should the state Supreme Court say no and they give me an en banc, I have an extremely powerful argument to the United States Supreme Court, because 18 USC 2339 Bravo, these are the FTOs. This is an FTO now. Oh, what? FTO, January 25, Jan 25, 2025. These people are now what's called FTOs. So the attorney and this person seeking to extract information through a manipulation of the machinery of justice in the proceeding to be able to furnish this information here, that's 18 USC 2339 Bravo. I say Bravo, but it's 2339B. That's providing material support to an FTO. And they can't say, oh no, we're just doing our job and I'm an attorney and I was doing what's in the best interest of my client. Not when you put somebody on the stand who these people did harm to, and this person in kind comes back at it, and then this person and her attorney, let's call that guy Gregory Carl Winter right here, he uses the machinery that Victoria Wood, Honorable Victoria Wood, she's no longer a judge, she's retired, she's now an alternative dispute resolution, she's like a mediator, a private judge in the Bay Area, but because she failed to use that lever to say, no, we are going in camera, you're not going to be able to use this. Or if the district attorney's office, the person in the district attorney's office is a friend of this person right here, right? And all of the judges have used that person's investigative findings and testimony. So what kind of love are you going to get from the court? But I have to admit, Honorable Victoria Wood, man, I feel really bad, Honorable Wood, that we're even in this position in time. But because of what you did, your friends, Robert Stamps, Joseph Solga, all these other people, they've placed my son in harm's way. And I told you that day that I'll do what I got to do. I'll travel the country, walk around the buildings with a megaphone, that I go to DC. I said as much, and I've honored my word. But this is nonviolence right here, man. These are pieces of paper, man. But what you guys have done to me, these people don't use pieces of paper, man. They don't use paper. And I told you guys that, and you didn't listen. So now your friends have made it so that your protection measure for my son, it don't mean nothing because of Joseph Solga and what Robert Stamps and them are doing. So it's your friends that everybody should know that you failed too. You failed me and my son. You failed to give me needs-based attorney's fees when the law said so. You decided to legislate from the bench and rewrite your own version of the law, placing me and my son in harm's way. You failed to go in camera and allowed for these people to extract information to be given to these people. And I told you that she had made that threat, and you didn't want to listen. What'd you say? Oh, Do you have a do you have a do you have a do you have a bladder problem? When I was like, hey, Your Honor, there's these pictures right here. Oh, they're all like, oh man, they're grainy photos. I can't really see them. Oh, I have colored ones right here. Objection, Your Honor. Oh, sustained. She sustained the ruling that would allow her to see the color clear photos of the defendant, this person, doing the worse things than what cost her parental rights to her first son. But Victoria Wood didn't want to see that. And what did you say? Do you have a bladder problem? I was like, what? A bladder problem? Do you mean an alcohol problem? You mean a getting drunk problem? That's what the problem is. That's what the pictures support and the video evidence. Well, what did you say? Oh, well, people get drunk around here. Well, let me tell you a little something, Honorable Wood. I'm their driver, just like I told you. And they don't bring their kids to get hammered in front of their kids. No, they pay me to drive them so they can get turned up. Cut a rug, baby. We're going to cut a rug. We're going to drive out there. No, they don't bring their kids along with them. And that's what this person does. And you could have seen the pictures, but what did you do but sustain the ruling and then said, do you have a bladder problem? And when I told you that people about not the hippocampus? Oh man. There's a hormone that's released in our brain when we consume alcohol that forces us to urinate more. So when people drink, oh man, what is that hormone that's released? It's produced in the pituitary gland and released from the hippocampus to the hypothalamus. I mean, this is what I had to go learn. And I cited all this. So what they say, oh, you're not a doctor. I don't need to be a doctor to read accepted medical science. Just like the constant of gravity. You don't have to be an astrophysicist to read what the constant of gravity is. 9.8 meters per second, or whatever, you can say squared, whatever. That's a constant of gravity. It doesn't change. We've accepted that that's a constant of gravity. That way, when you do a mathematical formula to be like, okay, if something falls from the sky, it falls for this amount of seconds, it weighs it, blah, blah, the constant of gravity, that's how you get that, okay? I don't have to be an astrophysicist to understand that the constant of gravity is that. Just like, oh God, I can't remember what the dang, the hormone is. But if you drink, that's why you get dehydrated and all that stuff. So I was like, so if she had a bladder problem and she's drinking and releasing that hormone in the brain, mm-hmm. And like I said, no disrespect to Honorable Wood, man, because she was the only one that did. Shout out to Price too, but Price knew that something was wrong here. I kept telling Price, hey, yo, this ain't right, man. There was no CPO in place. This person, they're trying to retaliate, and Price just sat there and threatened me from California into the Commonwealth of Virginia, saying, if you don't take this, then I'm going to put a warrant out for you. That's what Diane Price said. That's on the record. That's in the audio. So Diane Price read all this and knew this, and I kept citing it on the record and threatened me across state lines that, hey, we're going to email you this using an electronic device over state lines to facilitate under duress a threat of to facilitate fraud of good old Allison Haley, right? So Honorable Wood, Robert Stamps, and Joseph Solga and them, they're making this worse. You know what I sat there for an hour and explained to you the significance of what happened, why I did it, how it happened, the people who are gone and why, and your friends, or so you would think, they've ensured that this is going to happen. I've already accepted that these people, they'll find their way, and this person's going to help them. I've accepted that. So as many people as will listen and can hear, they're going to know what all of you guys did, all of your failures to operate the machinery of justice. Solga putting nothing in writing. The Court of Appeals, Tracy L. Brown saying that I didn't challenge the merits of the lower court's argument. What merits? There is nothing in writing. There's no written nothing. So that was a ridiculous farce. And I'm going to read that to you guys. But that's your indicator that the Court of Appeals was complicit as well. Because the justices should have been like, there's nothing here. We can't But instead, they're like, yeah, there's nothing here, and you didn't challenge. What's zero times zero? It's zero. Nothing from nothing leaves nothing, right? Had to do something. But what did Tracy L. Brown, the presiding judge, who, if you watch on YouTube when she's promoted to the presiding judge, everybody said how she's the fairest, the most wonderful. Oh, this guy gets up and he says, oh man, if you had her on your case and you were the prosecution or the defense, you were happy as a clam. He didn't say happy as a clam, but he said both sides were happy because you just knew that she was fair. Where did she go wrong? And why did Tracy L. Brown go wrong? Why did Tracy L. Brown, seeing the criminal history of this person, the significant 3-page DOJ report? I can't manufacture a 3-page DOJ report, right? No. See, Tracy Brown, she saw all that. And if you haven't heard oral arguments, you can hear me present all this to them. I straight out said, I said, look, if you are that person, and I made this argument, and if I'm given the opportunity to make the argument to the United States Supreme Court or to the Fourth Circuit Court of Appeals here in the Commonwealth, or to the Supreme Court in the state of California, they're chewing on this right now because it's like, dang, man, when you really take the whole thing, it's like a stack of a whole bunch of really bad decisions. And there's no way that they can be unintentional or just, oh man, this is, just a side effect of how could they have known, man? How could they have known? It was like a big elephant with glow sticks all over it and a strobe light and glow in the dark paintings and stuff. It was so obvious. So that's your indicator that their actions were willful and intentional, that they were overt, predicated acts. This wasn't some just accidental, you know what I mean? This wasn't just an unintended side effect. All right, key additions and improvements to the redraft. The Knox, the Family Code 2030. Remember I told you guys, Family Code 2030, it's mandatory. The legislators removed judicial discretion. Before, they had judicial discretion to say, like, you know what? No. Yes. No. The legislators went in and they said, hey, if we don't do something to remove the judicial discretion, people's rights can be just decimated. That means that somebody can go in there and throw a bunch of money around, file. Oh, I got money. Woo, I win. I got more money. The other person, no, okay. So the legislative intent was to create parity where disparity exists. To create parity where disparity exists. So if one person got like that much money and the other person got a nice fat stack, this person, they don't want the case to be decided on that. They want it decided based on the merits. So the legislators went in and gutted judicial discretion and they made it mandatory, must, shall. Then cases went along the lines and people cited those cases. In re marriage of Knox, Dawson, Bear, Knox, right? Exactly what happened in Knox is what has transpired. Is it my turn? Okay, all right. Well, folks, my time is up. It's good to see you guys again. I have to hand off the room to the next wonderful person who is utilizing the library effectively. Oh, look, my nose is all red. All right, I got to go.